Hi, Julie Paquette, probate and estate planning attorney. Today I want to talk about someone giving notice that they are seeking to serve as personal representative of a probate estate. So you may get notice at some point from an individual with probate court documents, and in those documents, it may be indicating that this individual is seeking to open a probate estate and have themselves or nominate someone else to serve as personal representative. That's generally how a probate estate begins, unless it's with a hearing in front of the court. But a lot of times we can open a probate estate simply by sending out notice to all of the parties who have an interest in the estate. That first step is simply to get the estate open, and opening an estate, there has to be an individual who is put in charge of things. And in Michigan, we call that the personal representative. A lot of people refer to that as the executor. So that individual seeking to be appointed as the personal representative or the PR is not necessarily asking to inherit either the entire estate or a larger share than what they're entitled to. That is simply that first step of putting someone in charge of things, getting the ball rolling, and then allowing that individual to be the person who's going to collect the assets, pay whatever debts have to be paid, administrative expenses, and then pay out the shares to the individuals who are entitled. So sometimes people call our office after they receive a notice like this, and they're kind of freaked out or they're very upset. And they're like, hey, why is cousin so-and-so trying to take over this estate and take everything? And I'm supposed to get a share and things like that. That's not what's going on at the very beginning. If you see in the documents, you'll see other parties who are listed. And generally those other parties are listed because they are standing to take part of the estate, but that's at the tail end when things are being wrapped up and shares are getting passed out. At the very beginning, it's just step one: who is going to be put in charge by the court to manage everything. Now, if you have received a notice like that, and it's not from our office, but you got it from someone else, you absolutely do want to contact an attorney, see about getting a consult set up and finding out what's going on. If you've been given notice, you're probably going to be informed of what's going on, but you may have a reason you want to show up to the court and object to that person being appointed as the PR, or show up at the hearing. But there's very short time limits with what you're allowed to do. So you want to call an attorney right away. We would be happy to consult with you and give you a little bit of guidance, what's going on, what would be the next step, and whether you should possibly object to that person, or if maybe you don't need to do anything right now and just see how things go. But you don't really want to make that decision without having all the information as to what your legal rights are, what the impact to you or your share or your interest might be. And you really can't do that without having the assistance of a probate attorney who knows how these things work. So feel free to give us a call. We're happy to schedule a consult with you, and we will talk to you soon.